Well, the Supreme Court of the United States is back in session with plenty of pressing issues and a new face. Justice Katanji Brown becomes the first black woman on the court.
Last term included monumental decisions on abortion and gun carrying rights, and this term has cases that could have major impact on affirmative action, voting rights, and religious freedom of speech.
So here to shine some light on the issues is Brooklyn Law School professor William Araiza. His areas of expertise are constitutional law and administrative law. So thanks so much for being here.
Happy to be here. Thanks.
All right. Well, Professor, before we get to the major cases, what's your sense of what Justice Katanji Brown Jackson's impact will be? I mean, she is considered part of the so-called liberal bloc, and they're still outnumbered. But yesterday, she was very vocal in her questioning.
Yes, I mean, her first day into court seemed to be one in which she showed her colors as an aggressive questioner, an informed questioner, and it's going to be very interesting to watch her first written product when she gets her first writing assignments later on in the term.
Yeah, there's going to be a lot on the table. There are two cases involving affirmative action that could overturn a 1978 decision that essentially let colleges use race as one factor in admissions. The two cases have been separated, though. So let's start with the Harvard case. What's the issue there?
So the issue in the Harvard case is whether Harvard violated Title VI of the Civil Rights Act, which basically prevents institutions getting government money from discriminating on the basis of race. The question is whether they violated Title VI through its admissions policies, which are alleged to unfairly or discriminatorily keep out especially Asian American applicants.
Well, there's also a case involving the University of North Carolina. How is that case different?
That case is different because UNC is a state actor. Because as a state actor, it is subject both to Title VI, because UNC gets funding just like Harvard does, but also UNC is subject to the 14th Amendment. And so there are 14th Amendment issues in the UNC case that aren't present in the Harvard case, although the legal doctrine will likely be quite similar under both sources of law.
Okay. Well, moving on to voting rights, there's a redistricting case from Alabama, and that could mean that states don't have to build districts that have a minority majority? Is that the case?
That's exactly right. So Section 2 of the Voting Rights Act prevents state action that impairs the ability of minority voters to vote. And that has been interpreted so as to require states to provide opportunities for minority voters to elect their preferred candidates. In a situation where there's racially polarized voting, that is to say, a situation where, for example, black voters tend to support one candidate while white voters tend to support another. Section 2 has been interpreted to require that states create districts to allow blacks or minority voters more generally to elect their preferred candidates. Alabama pushed back on that. Alabama has 27% black population, but out of its 7 districts, only one of them is reserved or primarily black, and that's alleged to be a Section 2 violation. Alabama disagrees.
Okay.
All right, so there's an interesting case pitting a state anti-discrimination law in Colorado versus religious freedom and free speech. What's at stake there?
So what's at stake there is the ability of someone to exercise a free speech right to oppose, in this case, same-sex marriage, as against the authority of the state to insist on non-discrimination in the sale of services. So this woman sells a service. It's a website service that announces marriages, but she doesn't want to sell that service to same-sex couples because she doesn't agree with same-sex marriage. The question then is, does she have a First Amendment right to refuse to serve same-sex couples, or does the state have a right or the authority to insist that she not discriminate based on sexual orientation? It's a tough question.
Now, let's look at something that's hitting us right here at home. New York and New Jersey, they're battling it out in a case involving the Waterfront Commission.
Yes,
that's the entity that prides itself, taking control of our ports back from the mob. So New Jersey claims the commission has basically outlived its usefulness, so they want out. So why are they before the Supreme Court?
Yeah, so this is the Battle of the Hudson. So, so New York and New Jersey signed a compact decades ago in the 50s to regulate what goes on at the ports and docks. New Jersey wants to withdraw from that compact. New Jersey thinks, as you said, it's outlived its usefulness. New York disagrees. The question before the court is whether one state can unilaterally withdraw from a compact or whether both states have to agree before the compact is dissolved. It's a technical case, but there are lots of compacts like that across the country, so it's going to be quite interesting to see how the court comes out.
All right, well, let's talk about the court itself. I mean, a lot of people would see it as hopelessly politically divided between conservatives and liberals. I mean, are there any Supreme Court reforms that could possibly come up, like adding justices or limiting terms at this point?
Well, there's nothing on the immediate horizon on that. But certainly there's been conversations about trying to limit the terms of the justices, at least going forward. Not to retroactively impose term limits, but going forward, 18 years has been bandied about as a good term limit. Staggered terms, of course, so that every president can expect to have at least 1 or 2 appointments during a 4-year term. So term limits are, on the maybe intermediate horizon, not the immediate horizon, taking jurisdiction away from the court over some hot button issues. That's always been something that Congress has periodically thought about doing. Increasing the size of the court, big hot button issue, great concern that if one side does it in 1 year, when the other side gains control of Congress, they're going to do the same thing. I wouldn't expect expansion to be a live possibility, but term limits might be.
Yeah.
All right. Well, Brooklyn law professor William Araiza, thanks so much for being here this morning.
Happy to do it.